Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, third or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report? With regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. With regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I just
Yes.
wanted to note, for purposes of today, that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
I will, and I did, and let me pull them up again just because I think that's been.
So specifically, they were not admitted for this purpose. They were admitted for bond.
Okay, that's right. Thank
for
you.
purposes of bond.
Okay.
However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior convictions and the current one for which he's on
Sure.
probation. And we hope that the court was able to look at that and considered that from 2001 to 2018, there was
Yes.
a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. I'd argue for Penn Diamond at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Mr. Gaytan was previously in court in cause number 25 DCCR 0184, entered a plea of guilty to driving while intoxicated third or more, which was enhanced to a second-degree felony because of prior offenses. The agreement was for a cap of 14 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Your Honor.
Are there any additions or corrections?
No, no Judge.
All right, Mr. Parker, you may proceed.
Just some of my client's knowledge. I've given the court and the prosecutor a letter of support from Frank Maida.
And I've received that and reviewed it as well.
And Your Honor, from talking to this man, talking to people that have known him, he is a good person that's just an alcoholic. And I think he was, I think he was pretty honest in his PSI. He talks about drinking at the age of 11, then 14, and then get to the point where he drank, at least a 12-pack regularly. He drank tequila and Crown Royal regularly until the point where he passed out and could never get enough. He's had several DWIs in the past. He's never had any kind of help at all. And I think he is a prime candidate for safety to get the help. He's had some periods where he's tried to do it on his own, and he was somewhat successful. He cuts grass for a living for several people here in Beaumont. He has the ability to make money if he's given the opportunity to be put on probation and go to the safety program. So he can do that. And it looks like to me that the PSI is also in concurrence that he would benefit from safety. And I just think that's the best thing for him, instead of just locking him up.
Thank you, Mr. Parker. Ms. Malfino?
Judge, I think it goes without saying that he certainly could use the help of safety. I think it also has to go without saying that prior to the criminal history that cannot be ignored. Obviously, of course, we'll defer to whatever the court deems appropriate. I respect Mr. Maida's letter. I take him at his word. But it's just difficult for me to argue both ways because I think he needs the help, but I also think we have the criminal history to take into consideration.
Right. And again, I mean, I think most of his criminal history is just drinking, and so many people have got the opportunity and it's worked for him, and he, you know, not from anybody's fault, you know, he's never got that help, you know. It's okay. Is there anything you want to tell the court?
They sent me to prison and made me work and work and work. They never teach me how to drinking. And I always go for games. I'm always making this to trustee. And I'm working on the freeways with Texas Department of Transportation, cleaning the roads, do anything. And disasters never give me a chance to.
But if you've gone to prison 3 prior times
Yes, ma'am.
for DWIs, 3 times you've gone to prison. So this is your 4th felony DWI.
Yes, ma'am.
This is at some point when you get out of prison, do you say, I need help and I'm going to get help for myself, instead of saying somebody else didn't help me?
I never had the chance. I have to look for work and.
But I know, but you have people like
Yes.
Attorney Maida. You could have said, hey, I need some help. You know people that can help me. I don't want to go back to prison.
Well, finally, this time I end up on the right city with the right people. Create a really good reputation. I met Mr. Maida, Dr. Suri, and a lot of good people, and they check my background, and Mr. Maida said my wife and me discuss, and we willing to give an opportunity. I've been working for them for years now.
Yeah, I just to make more clarity, I think that when he came here and he was working for the people around here, there were some things that he was doing, and he was not drinking. I don't remember the incident, but there was an episode where he started drinking again, and it was pretty close to the time frame of this. This wasn't I'm not saying this is the only time, but he had started drinking again. And I don't take it that he was blaming anybody for not giving him help. He just said he's never had that opportunity. And, you know, when you're an alcoholic or a drug user or addicted to anything, it's easy for, you know, to say, it's the same thing with an abused woman. Why don't you just leave? Why don't you just leave? Just learn.
But
Stop drinking. And it's hard. Yeah.
I don't disagree that it's hard. But I also, if you'd never been to prison before.
Right.
And if you hadn't had kind of the wake up call of prison to say, I don't want to go back to prison. I need to figure out how to stop drinking. And then you get out and then you do it again. Well, I didn't figure that out. Let me go
Right.
do it again. Your blood alcohol was 0.257. You ran off the road. You could have, I mean, there's just too many times that I see now, unfortunately, people in here where we're looking at someone who is, has killed someone or hurt someone. And the fact that this is your 7th DWI, it's your 7th. I don't disagree that you need help, but I don't feel like now's the time for, and I don't know what happened in those cases in Harris County and Bexar County. You know, if you were given an opportunity, at some point, I feel like there's opportunities for probation where people decide not to do that because sometimes doing a few years in prison is easier.
Well, I think
It's
some of these-
odd to me that there has not been a probation.
I think some of these, he sat in jail and wasn't able to bond out, and it's one of those deals, you know, we'll plead you to 2 years or 4, I don't remember the numbers, but, and so,
I mean, you got 12 years back in '04. 12 years for your DWI, second felony DWI. Then you got another one after that, and for some reason Barrett County said, well, let's give them less time. Let's give them 5. Let's reward them for continuing the wrong behavior. Anything else?
I mean, the same thing, I just see people that, I mean, it's, you know, I concentrate solely on the fact that his criminal history is alcohol, and there are people that we've seen on their 4th or 5th that we've given safety to, or people that are on probation. People are on probation for DWI, and they violate the terms of probation by drinking, and they come back before, I mean, all these courts, and several times we say, hey, let's give you safety, you know, and I can make the same argument, you know, you just went to court, you know, I mean, I get it, but I don't get what people think. But I just think he's a prime candidate for safety, and he would benefit from it. He's a good person. He'll work. But I understand the court's position.
Can I say something?
Yeah, sure.
I've been sober since the
I'm sorry.
I've been sober since the accident. I moved to a small chair.
You've been sober since the accident?
I moved to a chair that is on the back of the property, Mr. Maida, and he said one condition, no drinking. And I respect that, and I've been doing exactly what he says. Because I know he's the only one of the few persons that believe in me, and he's given me a great opportunity. I know it's the chance of my
I can't,
life.
slow down.
He said he's one of the only ones that will give him an opportunity. He knows he's serious about it. He's allowed him to move on the back of his property in a little room, I think.
We even went to what they call a retreat. He asked me if we were willing to go, and I said yes, sir. And we spent 3 days. And he's a great person. He's been helping me a lot.
So here's the thing, if I even were to consider, which I'm not sure why I'm even considering, but I might, giving you a probation, you would not drive ever a
No,
vehicle.
ma'am.
I mean, it would be part of your probation. So you're gonna have to,
No, ma'am. I
ever.
haven't get a car.
Listen to her.
I mean, it would be a condition of your probation that you never drive the entire time that you're on my probation. I mean, you understand that?
Yes, ma'am.
So,
Judge, if it would help the court, I'd be happy to, try to get with the probation department and get with those other district attorney's office and see if there's ever been a probation on any of those cases that have been subsequently been violated.
I think they typically are listed in here that way. And so it doesn't appear that there ever has been one. I guess one of my dilemmas now is if I do consider probation, it would have to be a straight probation and only for the 10. And I lose that opportunity that I have today to give up to 14
Well, you could
years.
possibly, one thing we could possibly do is sentence him to 10 over 10, give him 180 days upfront and hold that in abeyance as a condition. I mean, which just extends it more. I mean,
Nah,
like
I don't know that it really extends the time. It just gives them time
Right.
potentially.
yeah.
Okay, here's what I'm gonna do, Mr. Gaytan. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated. I'm going to give you an opportunity today that you have not had, but there's going to be some conditions on this probation, and you will be on 0 tolerance. And what that means is that any violation, is going to get you right back in here with the sentence that I'm giving you today. I will make a notation, there will not be plea agreements on a motion to revoke your probation. If you violate, and I find that you violated, that's it, you're done. Do you understand? So I'm going to sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You're on probation for 10 years. I'm going to order as a condition of your probation that you enter and successfully complete the SafeP program, and that when you're released as part of the aftercare, you will then enter and successfully complete the JCDI program, which is an outpatient program. You will be ordered not to drive any vehicle ever whatsoever. You will also be ordered to wear at all times a scram device. That's a device that will tell me if you have alcohol in your system. If you test positive on that, when you get out after SafeP and you test positive for alcohol, you will immediately be back in here and go into prison for 10 years. It's that simple. It's the length of time that you have been an alcoholic. This is going to be a very difficult process, but either you want to do it and go through that difficult process, or you want to spend the rest of your life in prison. So that's going to be up to you. There's no, I relapsed and this is a difficult thing, and I understand that. This is it. You will be ordered to serve 10 days upfront time as a condition of that program. That's required. You'll obviously get that time in while you're waiting to go to SafeP. Anything else condition-wise that anybody can think of? I'm sorry. I'm going to order a $500 fine. All right, so I think that covers it. And so, Mr. Gaytan, I hope you take advantage of this. It sounds like you're ready finally at this point in your life. I hope you take advantage of it, because again, this is the only opportunity you're going to get here in this court.
And thank you, I appreciate
Would you
everything.
have any ability to pretty tightly monitor his no driving? I mean, I know that's just,
I don't know how to, because if I put, a GPS won't do it, because if he's in somebody else's vehicle, I mean, I'm inclined to reach out to,
maybe some of those people who have reached
yeah,
out for him.
so I'm inclined to reach out to Mr. Maida and explain to him
I will explain to
about
him.
the no driving, because I know Mr. Maida is the one that helped get him that vehicle in the first
Right.
place that ended up, I think, part of this wreck.
Right.
But when I say no driving, it doesn't mean in a couple of years I get some request that, hey, he's been doing great, let him drive. You're either riding with someone, or you're on a bike, or whatever else, or walking. And that is the most serious part of what I want and need to do to make sure that the community's safe. Do you understand?
Yes, ma'am.
Ms. Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney
Okay,
while I was in jail, so that's why I can't urinate.
okay. Because I have notification,
The lady came from Buena to put the patch on. It was real late at night at jail.
so I have notification dated yesterday, the 6th, that you got a drug patch on August 31st, when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what I don't have, that's not true. So I'm going to
I
find,
had the paper at home. I didn't bring it with me.
well, you didn't show up yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks. is
Right.
when you change it.
Yeah,
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
You being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right,
Okay.
yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your
I
chair.
have been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You go back with the bailiff.